completed ballots. They could not obtain or apply for ballots at that event, and therefore 6.855 does not apply. This was not early in-person voting. Instead, these events were governed by 6.874B1, which is the provisions. The Election Commission has interpreted this provision to allow the use of secured ballot drop boxes in a variety of circumstances and locations. This was one of those circumstances. These were staffed drop boxes in parks, and they were functionally identical to the staffed and unstaffed drop boxes that have been used for many years in Wisconsin. Your Honor, the last point on this is the statute provides that for delivery of these ballots, delivery in person to the municipal clerk is permissible under 6.874B1, and that's exactly what happened here. These ballots were delivered to agents of the clerk in the parks, entirely consistent with the express language of the statute. And the boards therefore properly concluded the ballots cast in these events were lawful. And once again, there's not evidence that a single person who delivered their ballots at these events voted improperly or unlawfully. Your Honor, my final 2 points, and I'll be very brief on these, goes to the constitutional violations that would result from granting the relief that plaintiff, President Trump, seeks here. And I'll focus first on due process and second on equal protection. The procedural and substantive due process issues here cry out for attention. What's being asked here is to change the rules after the game has been played, and fundamental due process prohibits that. Voters were not on notice that the rules would be changed in this way, of course, and it goes to the heart of due process that you cannot do that after the fact and disenfranchise hundreds of thousands of voters. I just refer you to our brief on due process without getting into the case law, but Your Honor, I'm sure is very well aware and well versed in due process law, but this would be one of the ultimate violations of both procedural and substantive due process to have the changes after the election that President Trump is seeking. And then finally, Your Honor, is equal protection. I made the point earlier that the relief being sought here is targeted at 2 out of 72 counties. In the other 70 counties, as the record demonstrates, voters voted in the same way. They relied upon indefinitely confined. They relied upon WEC guidance, the clerks did, with respect to adding witness information. Voters throughout the state use the form for in-person absentee voting, just as the voters in Dane and Milwaukee did. And under the Equal Protection Clause, Your Honor, it would be an egregious violation to discount just the votes of voters in Dane and Milwaukee as being requested here. In Bush v. Gore, the Supreme Court said that the fundamental nature of the right to vote means equal weight accorded to each vote and the equal dignity owed to each other. Here, if the relief plaintiffs seek were granted, 220,000 Wisconsin citizens would have no weight accorded to their vote and certainly would not be afforded the equal dignity that voters in 70 other counties are receiving. Your Honor, for all these reasons, plaintiffs or President Trump's challenges and requests for relief should be denied. We respectfully ask that the court do so.
Thank you, Mr. Devaney. Have you consulted and agreed on who goes next? Mr. Kilpatrick, raising your hand. Let me just check with the reporter. You're okay on the time? Okay, Mr. Kilpatrick, go ahead.
Thank you, Your Honor. I will be brief. I just wanted to say that the Election Commission does not take sides in the election. The side of the Election Commission in this appeal is to defend its decisions. And I asked that the court, if it would take judicial notice of those Election Commission memos that were attached to Administrator Wolf's affidavit, Those are public documents and they can be taken judicially noticed of. They're all on the website. That also goes to the laches argument in that it is clear that the plaintiffs had knowledge and notice of the commission's guidance. These were all publicly available guidance. They were distributed throughout the state to all the clerks. All the candidates and political parties had knowledge of those for years. For example, the guidance regarding the application actually was created, the EL 122, approved unanimously by the Government Accountability Board, the predecessor agency of the Elections Commission, in 2009. The application began use in May of 2010 and has been used ever since. And so any challenge could have been brought literally years before. With regard to the indefinitely confined aspect, again, the plaintiffs were on notice of that. As this court is aware and the briefs make clear, there was a pre-election suit brought by a political party before the Wisconsin Supreme Court in March about a local official's statement. So it is unpersuasive that the plaintiffs argue that they could not have brought any suit prior to the recount. It's clear in Wisconsin that that did happen months before this November election. And I also would like to note, with regard to the indefinitely confined issue, is that the Wisconsin Supreme Court approved in a preliminary relief order the guidance that the commission issued and had no problem with that back in March. That's all I have to say. I think Mr. Devaney did a fine job providing a defense altogether with the defendants. Thank you.
Who wishes to proceed next? Mr. Jones?
Yes, Your Honor. I'm not sure if I was supposed to go next, but not seeing Mr. Galt raise his hand, I will go next. And like other counsel on this side of the table, I am mindful of the voluminous submissions that are in front of Your Honor and Your Honor's statements at the beginning of argument. So I too will keep it succinct, or at least try to. I know lawyers say they will and often don't, but I will do my best. There's really just a few points I want to make, picking up on some of the things that have been said in argument, in particular by Mr. Troupas, and then just to highlight a couple of other points on the various defenses that have been raised. With respect to the laches issue, I would point Your Honor back to just the elements of that defense in Wisconsin, those elements being 3, unreasonable delay in bringing a claim, 2, a lack of knowledge by the party who's asserting that defense that the other party would assert the claim, and prejudice. And the argument that I think I hear coming from opposing counsel really goes to that unreasonable delay element. And I think the facts here, the record that was in front of these two boards, are very clear on the issue of unreasonable delay. And I think what opposing counsel is trying to do now is characterize these claims or these challenges that are being brought via the recount really as being about particular voters. And of course, now at this point in the proceedings, President Trump is aware of how many voters fit into a particular category or categories as a result of the recount that occurred. But this is not a challenge to particular voters or particular ballots. And I think that's obvious for a number of reasons, not the least of which being the way that the recount petition itself was framed. The petition was framed in terms of alleged statewide errors in the administration of the election. I would point Your Honor to paragraphs 4B, 5B, 6C, and 6E of the recount petition. Those paragraphs all allege statewide misadministration of the election. The Trump campaign knew going into the election that those alleged problems in the administration of the election were out there. It's not about individual voters or individual ballots. And the facts relating to those alleged, and I underscore alleged, errors in administration are obviously all facts, matters of public record, for reasons that the briefs explain that Mr. Devaney and Mr. Kilpatrick have already emphasized, for your honor. It's very clear on the record that there was unreasonable delay here. Another point that I'd like to emphasize, for your honor, that I think is implicit in what the other defense counsel have already said, but that is that part of this strong public policy in Wisconsin that favors the counting of all votes, which is expressed in section 5.01 sub 1 of the Wisconsin statutes, and cases such as the Zimmerman case from the Wisconsin Supreme Court in 1949, cited by the parties. But part of that strong public policy, or part of the way that policy has been enforced by the courts, is this idea that we don't throw out votes in Wisconsin when the error at issue is official error or error by election officials, rather than error or misconduct or perhaps even fraud by individual voters. And I won't go through all those cases, but I would simply re-emphasize that point and point your honor to the cases that we cited in our brief at pages 11 and 12. That's a line of cases that goes back over 100 years. And I don't think there really can be any argument that what the petitioners here are contending is that there was error by the election officials. There is no allegation, there certainly isn't any proof of voter error or voter fraud. And I think on the strength of that line of cases, the court really is not in a position where it can throw out votes for the reasons that are being asserted here. I have only two brief points I want to make in terms of the merits of the claims with respect to Wisconsin election law. One relating to the in-person absentee ballots specific to Milwaukee County, and the other about the indefinitely confined absentee voter issue. The first being that the board in Milwaukee certainly reached the conclusion that the almost 109,000 ballots that the petitioners are challenging, those all being in-person absentee ballots, were supported by a written application, in that each and every single one of those absentee voters filled out this combined application certification form, the EL 122. So without question, there was a written application in that form. The board also addressed, however, the fact that the way it works in Milwaukee County for all of those 19 municipalities is that when someone walks into the clerk's office to vote in-person absentee, the clerk, checking their ID, inputs the fact that the voter is requesting a ballot, an absentee ballot, into the My Vote system, if I've got the name right. So in that moment, when the voter is present asking for a ballot, the clerk is essentially doing online what hundreds of thousands of other Wisconsin voters did in requesting absentee ballots through the online system. There is then a written record of that transaction, so to speak, that's created, just like there is a record of every other voter who applied for an absentee ballot online in that way. The petitioners are not challenging those hundreds of thousands of voters who went online and asked for an absentee ballot in that way. And there is absolutely no reason to treat any of the 109,000 Milwaukee County voters who went in and asked for a ballot in person, but through that process essentially also applied online. There's no reason to treat them any differently and to throw out those 109,000 ballots. The last point I'd like to make, Your Honor, again on indefinitely confined. Certainly the arguments made in the briefs go to the fact that the guidance that was at issue, issued by the WEC in March, was essentially 100% correct under the law, and the Wisconsin Supreme Court said so. But I think an even more fundamental point for Your Honor to consider is the fact that it's really nothing but supposition or speculation that the petitioners are relying on to suggest that any, or as they argue, all of those voters in Milwaukee County, almost 20,000, were not entitled to claim indefinite confinement status. I mean, the argument is, well, the numbers went up, therefore some or all of them must have been invalid or inappropriately claiming that status. But the fact of the matter is, the burden of proof was on the petitioners at the recount to present evidence that any of those voters inappropriately claimed that status. There was no such proof, not any proof of a single Milwaukee County voter who should not or could not or was not entitled to claim that status. Certainly not proof beyond a reasonable doubt, as the law requires with respect to any individual voter. They had the burden of proof. They failed to meet it. There is absolutely no basis to throw out any of those ballots. I'm going to rely on the arguments in the briefs as to the cure. I think that to wrap up or to close, certainly it's understood that the legislature intended that absentee voting in this state be closely watched, regulated. That's clear in section 6.84 of the statutes. But it's also clear that this appeal does not truly serve that legislative purpose. That purpose is not served by over-technical, formalistic reading of the statutory requirements for absentee ballots. And I think it's clear based on the submissions that that is what is being advocated by the petitioners. That purpose, that legislative purpose, is not served by speculation about wrongdoing on the part of voters. And that's absolutely what is being advocated with respect to the indefinitely confined voters, if not the other categories as well. And that purpose in 6.84, that legislative purpose, does not require Your Honor to abandon the strong, long-standing public policy of the state to give effect and meaning to the right to vote and to honor the will of the electorate. And I think being faithful to that public policy purpose, while still respecting the intent of the legislature regarding absentee voting, requires, Your Honor, requires this court to uphold the determinations of the Milwaukee and Dane County boards and to dismiss this appeal. Thank you.
Yes, Mr. Galt.
Thank you, Your Honor. I'm going to try to be really brief. My primary concern in this case was two issues that were somewhat centered to Dane County, and that was the indefinitely confined issue and democracy in the park. I think those issues have been fully addressed by the briefs as well as argument by Mr. Devaney and don't need any more attention here. I do briefly just want to touch on one issue raised by Mr. Troupas this morning, and that is the role of the Board of Canvassers in reviewing absentee ballot applications. And I wrote down a couple of quotes here by Mr. Troupas. One was that the Board of Canvassers had an obligation to follow the statute, and number two, that the statutes say what they say. And I agree wholeheartedly with that. I also agree that the Board of Canvassers was required to seek their own independent legal counsel and not just follow the Election Commission's guidance on that. And I can tell you with respect to Dane County, they did, because I'm the one who gave them the independent legal counsel. And what I would tell you, Your Honor, is that Wisconsin statute section 9.01(1)B sets forth a very specific procedure for the Board of Canvassers to follow in conducting the recount. It lists step by step what the Board of Canvassers are to do. It says that the recount shall proceed for each ward or municipality as follows, and then those steps are listed. As to absentee ballots, the Board of Canvassers has an obligation to examine the absentee ballot envelopes. And then there is very specific guidance on when an absentee ballot is defective. There is no mention of a review of the absentee ballot applications as part of the recount process. It simply is not something that the legislature told the Board of Canvassers they were supposed to do as part of the recount process. And that was the advice that was given to the Dane County Board of Canvassers in conducting their canvass. I suspect they got the same guidance in Milwaukee County. And I just wanted to correct that because there was an implication raised that somehow the Board of Canvassers didn't follow the statute by not reviewing those applications, and that's simply not the case. Other than that, I believe all the issues have been fully briefed, and those issues are covered, and we would rest on the brief submitted and the other arguments of counsel. Thank you, Your Honor.
Anyone else? Respondents? If not, then Mr. Troupas, any rebuttal?
Yes. On a couple of items that I think are just misstated. Let me begin with the idea that there's somehow proof in this record that the clerks elsewhere in the state did things exactly like Dane and Milwaukee County. And for that, they cite the only piece of evidence apparently they have now, the Kennedy affidavit. I'm looking at the Kennedy affidavit. Kevin says nothing about what goes on elsewhere in the state. Not a word. He is talking about the process